Welcome back, Consumer Law 101 students and scholars. My name is Aaron Swift. I am the CEO and managing partner of Swift Law North and Consumer Law 101. Today we are continuing our series on the Fair Credit Reporting Act with part 3 of the ABCs of the FCRA, statute of limitations and common defenses. All right, so we're going to start with an agenda. In today's lecture video, we're going to talk about the Fair Credit Reporting Act statute of limitations. We're going to talk about what that standard is and give some examples. Then we're going to go over 3 to 4 common defenses that defendants in these cases may raise, and then talk about how you can protect against them. And lastly, we're going to talk about the potential for counterclaims in these cases and the general connection of this topic to credit repair and litigation-backed credit repair in particular. All right, let's get started. Okay, so as you probably know by now from other videos, in particular the FDCPA, the SOL is the statute of limitations. That is the time frame within which you can successfully sue for a claim. Most statutes have them written into the statute in black and white about what the exact SOL is. Other times you have to look to a separate statute of limitations statute to really identify. And sometimes, like for example in Florida, you do have to look to that separate statute on written contracts, which is then, defined in that statute versus other types of contracts that aren't. So, under the Fair Credit Reporting Act, the FCRA, there are 2 alternative types of statute of limitations. First is within 5 years of the violation, or within 2 years of discovery of the violation, whichever is sooner. So let's talk about how that works out in an example. So let's say a consumer can prove that they paid on time a Capital One or another credit card bill, but Capital One or whoever else the creditor is reporting a late payment of 30 days. Well, if that took place 5 years and 1 month ago, that's when that 30-day late. Well, unfortunately, there's not much that can be done. That violation took place over 5 years ago, and that would be past the statute of limitations. Also, what happens if 3 years ago, the consumer discovered that by pulling his or her credit reports and saw that the 30-day late, that's fictitious and false, and then thought, I'll get around to disputing this or suing at some point, but never did. Well, now it's not even 5 years. It's from 2 years from that date, 3 years ago, when the consumer discovered the violation, and it would also be past the statute of limitations. One really interesting note, though, in these types of cases is, as you probably know or hope you know, and you're going to learn if you don't, is that a lot of claims require disputing first. And that could be disputing to the credit bureau, one or all of them, and then a process continues from there, which we'll get into later in the course. But the fact that you can dispute and that triggers requirements and responsibilities that the defendant or defendants investigate, you can effectively restart the statute of limitations in these cases by disputing again, because those types of claims, and as you see here on the screen, they're called 1681I claims against CRAs, and then 1681 S2B claims against furnishers. All of those can almost effectively continue to restart the statute of limitations basically for infinity until the issue is resolved, because every time an investigation fails to fix the problem, you'd have 2 more years from then to sue. So keep that in mind in these types of cases. All right, so let's talk about some of the common defenses in these cases. And if you go back to one of the original videos of the FCRA lecture series, you learned about common definitions and legal standards. And this is why we teach those. The fundamentals is because they then form the foundation of these types of claims, not only the elements of the claims themselves, but then the defenses that are raised by the other side. So for example, if a consumer tries to sue when the underlying information they're suing over is not found in an actual consumer report, as that term is defined by the statute, then there's no claim. That's why, for example, in our litigation program, and I recommend this for everyone, is pulling annual credit reports. Those are actual consumer reports. Reports that you get from resellers, like you see on the screen, or tri-merge reports from mortgage brokers, or Credit Karma reports, none of those count as actual consumer reports under the statute because they're not given or received directly from the sources of the information, so it's even less reliable. So again, that's why you have to really be careful about, are you suing over information that is found in an actual consumer report and not one of these other types of disclosures that can really give pitfalls because they don't qualify under the statute. Another one is if they're not a CRA. And again, going back to the definition, that's an entity who for profit generally sells or compiles information that is then sold for profit, and that information is used to determine someone's creditworthiness or their ability to get a job or an apartment or a house, those things. So if they're not a CRA, then they don't get sued under the statute successfully. For example, Facebook has been sued by some very aggressive plaintiffs in this world. And the courts routinely hold, listen, Facebook does have a lot of your information, but they don't really sell it. They don't repackage it that really impacts your creditworthiness, not in a direct way at least. And then LexisNexis is very unique. In some circumstances, Lexis is a CRA. For example, they compile reports called Clue reports about insurance issues or car accident histories. In those circumstances, Lexis is a CRA, but there are other circumstances where Lexis is not. So it just really depends. Another type of defense, common defense in these cases, is if there's no damage. And you may have heard this issue before. That's a big case called Spokio and some other cases after that in the Supreme Court that decided for a consumer, for a plaintiff to have redress, to bring a case in front of the federal courts, you have to have standing and an injury in fact. And that means it just can't be hypothetical. And I'll give you an example. A lot of these data breach cases, you get those flyers in the mail or your information has been compromised because of a data breach at this company, and that company held some of your records and they suffered a breach. A lot of those cases are being thrown out because what courts are saying is the plaintiffs in those cases haven't been harmed yet. Yes, their information was breached, but if the information hasn't been used to harm them, like for example, to commit identity theft, well, it's not enough. Personally, I really disagree with that because I think there's a really material risk and fear of future harm that should count. But in that case, courts say there's no true injury in fact. So that's why in our cases, the Swift Law North litigation program, we really dive deep into these, the impacts on economic ways, non-economic, types of damage in these cases to make sure that we can prove standing. And then lastly, we're going to talk about today a very, very new standard that the 11th Circuit here just came out with. Ironically, it's one of my cases. And it says that for a consumer to bring a claim, it must be able to have objectively and readily verifiable dispute information. And this is the, I would say, culmination of a legal standard that used to be called legal versus factual. And now this new objectively and readily verifiable dispute standard is so new, it's this month, that we don't yet know how it's going to play out. But it's important when you think about the Fair Credit Reporting Act and these defenses, is someone suing over something that's objective and readily verifiable? And those are the types of things we're going to be looking for. That's the type of thing that our course is going to teach you. We talked about this issue on the FDCPA, and of course we have to also address it now under the FCRA. Is there the potential danger for counterclaims? And the answer is absolutely yes. So we are very selective on cases we bring. We never want to put a consumer in more harm's way by, bringing cases against defendants to vindicate their affirmative rights. But if these cases, with a statutory damage of up to $1,000 and there's, let's say not a lot of other actual damages, well, if a consumer is going to sue for $1,000, but they owe $10,000 on a debt that's only 3 years old, then we're really not going to bring that case. We wouldn't recommend bringing that case. Because in that instance, if the debt is only 3 years old in most states, it's not past the statute of limitations. So if the consumer sues Bank X and says, you broke the law, you broke the FCRA, you owe me $1,000, well, Bank X says, great, I countersue you, you owe me 10, it's a wash, you owe me 9. So to protect against those, we are very selective. We investigate every debt that we come through in our program to make sure we understand when its statute of limitations is. Sometimes if it's low enough, if it's a couple $100 and it's not past the statute of limitations, well, we might bring that case because, at the end of the day, we probably are going to get the debt forgiven and have, some damages on top of that. And that's a really good segue to the last part of this, which is how to disconnect credit repair and litigation-backed credit repair. And it's all connected. To truly understand whether your consumers are going to have claims, whether how you can educate them, maybe bring them into our litigation program with a lot of knowledge, is to first start by understanding these principles yourselves. And you take those definitions we learned in video 1, and now you apply them to these defenses. You always want to understand, when is the statute of limitations? If it's, past the statute of limitations on a debt, well, that's going to really impact credit repair and what can and cannot be credit reported. And so using these fundamental principles, understanding common defenses, it's going to help everyone avoid major pitfalls. So that way, when we bring consumers through litigation, hopefully, they're going to get these higher, credit scores, because we're going to get trade line deleted. We're going to have, debt forgiven and waived. So understanding the statute of limitations and common defenses is going to go a long way to really make that solid connection so we can make more money for our consumers and for ourselves. So thank you. Again, I'm attorney Aaron Swift, CEO and managing partner of Swift Law North and Consumer Law 101. For more information, visit swiftlawnorth.com and consumerlaw101.com and continue on with our lecture series. Thank you.